All right, welcome everyone to the Institute for Corporate Governance and Ethics Spring 2026 Speaker Series. I'm Todd Haw, Associate Professor of Business Law and Ethics at the Kelley School and the Faculty Director of the ICGE. And I'm thrilled to be joined today by my colleague, Matt Turk, who will introduce our speaker, Anat Alon-Beck, and her talk, Delaware Beware, the Changing Landscape of State Corporate Charters, in just a moment. But before I turn things over to Matt, I'd like to say a quick word about the ICGE. The Institute for Corporate Governance and Ethics takes a broad, interdisciplinary, and systems-based approach to corporate governance and ethics research. So not only do we consider corporate governance in its full scope, which includes the areas of finance, management, corporate law, corporate compliance, business and behavioral ethics, and financial controls, but we also aim to make that research accessible to business practitioners. So as part of that effort, the ICGE brought Ethical Systems, which is a consortium of business and behavioral ethics scholars, to the Kelley School, which doubled the number of our faculty affiliates and created an entirely new network of collaborators under the ICGE umbrella, as well as a new platform to reach business leaders. So bringing the ICGE and Ethical Systems together has created a one-of-a-kind institution that is able to harness the best academic research to aid students, scholars, policymakers, and business leaders in elevating corporate governance and ethical business practices within their organizations. So this speaker series is just one of the ways that we're doing that. So please check out our websites and LinkedIn for new initiatives and activities coming from the ICGE and Ethical Systems in the future. And I also want to mention that we recently issued our first report, and we're going to be issuing sort of an end of semester update at the end of May. So you can see everything that we've been doing over the last year. Just keep an eye out on our social media or go to the ICGE website to take a look. All right, so now let me introduce the moderator for today's talk, my colleague and ICGE Research Director, Matt Turk. Matt is an associate professor of business law and ethics whose scholarship focuses on financial regulation, securities law, and international economic law. His work has been published in a number of top law journals, which include Northwestern, Iowa, Georgia, Alabama, and Washington and Lee, among many others. Before joining the Kelley School, Matt served as a federal law clerk on the Ninth Circuit Court of Appeals for the Honorable Ferdinand Fernandez and as a corporate litigator at Sullivan and Cromwell. He is a magna cum laude graduate of NYU Law School, where he was an editor for the Journal of International Law and Politics. So with that, Matt, please take it away.
Thanks, Todd, and good afternoon, everyone. Thank you for joining us. I have the pleasure of introducing our speaker for today, Professor Anat Alon-Beck, who will be talking with us about her article titled Delaware Beware and State Competition for Corporate Charters more generally. Anat is a professor of law at the Case Western Reserve School of Law. This past year, she has been a visiting scholar at Harvard Law School. Anat holds JSD and LLM degrees from Cornell Law School and an LLB from Tel Aviv University, where she served as editor of the journal Theoretical Inquiries in Law. Prior to joining the faculty at Case Western Reserve, Anat was the Jacobson Fellow in Law and Business at the NYU School of Law. Anat's research focuses on corporate law and governance, where she is a leading expert in what are known as unicorn firms, a term for large, privately held startups valued at over $1 billion. Anat's work has been published by the Vanderbilt Law Review, Illinois Law Review, and Columbus Business Law Review, among many other journals. She also has a column at Forbes.com and often opines on business law cases in various media outlets, including frequent television, radio, newspaper, and podcast appearances. Before I turn it over to Anat, I would like to invite you all to share your questions in the chat. I'll monitor the chat and we'll be sure to pause throughout the presentation for questions. With that, I'll turn it over to you, Anat.
Well, thank you so much. Thank you so much for having me today. It's a huge honor. I'm a huge fan. You should know that I live in Cleveland, Ohio, and a lot of my kids' friends always dream about attending your school. So it's an honor. So you just made me very popular among the youth. So
we'll take them. We'll send them our way, and we'd love to have them.
And I'm discussing today something that is so clear and dear to my heart because I've been dealing with this for several years. As Matt noted, I sit on the American Bar Association's Business Law section on a Venture Capital and Private Equity Committee. I'm the head of the academic subcommittee there. And I've been seeing this transition, right, all these questions, the tensions that came up, and then I started writing a piece that I called Delaware Beware. And I'm going to share with you a little bit of my journey of why I was writing that piece, why I was actually warning the Delaware courts, and then what happened afterwards. So sitting there, being an academic, sitting at the bar at that position with the leading law firms from Silicon Valley, New York, California, Chicago, Boston, everywhere, I knew the tension was starting with regards to Delaware, and that we are in the beginning of what is going to perhaps be a shockwave in our corporate law and our world. Let me just share my screen quickly, just 1 second. Okay, so it actually started with Musk, Elon Musk. I'm sure you're familiar, or some of you are following him on Twitter. And Musk actually tweeted, "Beware of Delaware." And I'm like, okay, I can't put that title on my paper, but I used that wordplay, and I said, Delaware, should you beware of what is going on? So what is going on? It's really extraordinary, and in many ways, perhaps even underappreciated, and that is, Delaware is a story of a success of the American economic history. It is the most dominant jurisdiction in corporate law, not just in the United States, but overall in the world, right? Now, you should note that Delaware is actually a tiny state. Yes, it's mighty, but it's tiny, right? We all know this. It has a relatively small population. It's not Silicon Valley, it's not New York, and it's not a major industrial center. But Delaware has become the legal home of corporate America. And in many respects, it is Delaware that governs the infrastructure of modern capitalism. And so what I want to explore with you and your audience today is not only how Delaware achieved that position, but whether we now have the market condition that will continue to allow Delaware to dominate this market, and whether something is beginning to change, or we're seeing a fracture in what's happening in the market competition for corporate law. In other words, should Delaware start worrying about the changes that we're seeing? Should we really be warning Delaware like I did in the paper and say, Delaware, beware? And Elon Musk's conflict with Delaware really became one of the most important modern corporate governance battle of really our era, because it had to do with founder control, with judicial oversight, executive compensation. Now it's also turning to questions of shareholder democracy. And people are discussing interstate competition in corporate law. Because what happened due to the Musk controversy is that effectively it turned the Delaware corporate law dispute into something much bigger. I think it turned today into a public political campaign almost against Delaware itself, against the influence that Delaware has. So let's start just quickly. Let me just tell the audience why is this happening? There were, by the way, multiple cases. It wasn't just Musk. There were a series of cases that when I was sitting in the committees at the ABA, I saw that that's what the lawyers were discussing. They were very concerned about a series of cases that were coming down. But the one that took all the public attention was with regards to Musk's Tesla compensation package. And I'm sure you've discussed compensation here before, right? Especially CEO compensation. And so in 2018, Tesla's board approved an enormous compensation package for Musk, and the package was really extraordinary. It was worth billions of dollars. It was based largely on stock options. It was tied to aggressive performance milestones, and it was one of the largest executive compensation plans in corporate history. And the Tesla shareholders voted to approve it. At first glance, it seemed that Musk, right, it was probably winning and doing everything according to the plan until there was a shareholder lawsuit. And that shareholder lawsuit was filed in Delaware. Now, this is very important to our discussion. Why? Why was this case brought in Delaware? Why was it filed in Delaware? And that is because Tesla is incorporated in Delaware, okay? So when we talk about the corporation, incorporations and competition between states, it's about the incorporation, okay? When you incorporate in Delaware or in any other state, because as you know, corporate law is not federal, it's state law, it changes from state to state. That means that if you incorporate in Delaware, Delaware fiduciary law governs your dispute, okay? In some situations, by the way, it depends on whether it governs the internal affairs of the company, okay? So this case specifically was heard in Delaware before the Delaware Court of Chancery. And this is very, very critical because Delaware's power comes from the internal affairs doctrine. And that doctrine tells us that the law of the state of incorporation governs the internal corporate matters of the company, okay? So even though we all know that Tesla's operations are mainly outside of Delaware, right? They're not in Delaware. Delaware law still controls. So even if you're headquartered, let's say in New York or California or wherever that is, it doesn't matter if it's about internal affairs, and then Delaware law controls, okay? Now, the litigation was brought by a plaintiff. He held a few shares in the company, and he argued that Musk effectively controlled Tesla, that the board was not sufficiently independent, that the compensation negotiations were flawed, and that the directors were too close to Musk to approve it, and basically that the process was not truly an arm's length process the way the Delaware law governs those types of situations. And I will say this again and again and again, and that is, in corporate law, process matters, right? I teach corporate law, and when I teach my students and I train the future lawyers and the ones who are going to be representing the largest companies here in the country, and I tell them process matters because it's about efficiency, okay? So even if shareholders or directors vote certain decisions, Delaware courts are still going to be able to examine whether there's conflicts, independence, coercion, disclosure quality, fiduciary duties, okay? So that these issues reflect Delaware's traditional governance philosophy, which is voting alone doesn't automatically cleanse fiduciary concerns, okay? We have to look at the process, whether, all the right steps were taken, and basically whether the company or the founder here listened to the lawyers, to the corporate lawyers who were representing there, whether they took all the necessary steps to cleanse that transaction, okay? And in this specific case, the court rescinded the package entirely, and it sent a huge wave in the media and overall, because it signaled something very important, and that is that even the world's richest and most powerful founder could be restrained by Delaware fiduciary law and doctrine, okay? And of course, then there was all this public fight, a very legal one, and also some will say even an outcry, because Musk personally viewed the decision as anti-founder, anti-innovation, anti-entrepreneurial, and he started attacking Delaware very, very publicly. And one of his most famous posts was what I just shared with you: never incorporate your company in Delaware. And he posted, "Beware of Delaware." And that statement was, to me, very extraordinary, because Musk was not just criticizing that specific ruling, but he was really attacking Delaware's legitimate purpose and founding, and what it became today really as this center of American corporate law. And that was and still is, by the way, a direct threat to Delaware's business model. Okay? Because Delaware, as Marcel Kahn noted, Delaware earns profit margins of several thousand% on its incorporation venture. And it looks like a great line of business to get into. Okay? And what happens is there's a huge market potentially where states can fight over this business of incorporation. And by the way, Delaware was not first. It was actually, if you know a little bit about corporate history, it was New Jersey before Delaware. And then Delaware was able to take that away from New Jersey. And then people are asking, are others going to be able to compete? And we know of some of the contenders. We have Texas, Nevada, California, Florida, Wyoming. So many other states are trying to compete with Delaware. And it's part of a larger debate that we're having, and that is with regards to, do we have a race to the bottom or a race to the top in terms of corporate governance and Delaware law? Because it has to do with managerial freedoms, shareholder welfare, overall regulatory competition. And then the question is, what's going to happen next? Let's go back quickly to why we're having the discussion. If we go back to Tesla, another very monumental thing happened, and that was the Texas move. So after that ruling, Texas shareholders voted to reincorporate Tesla in Texas. And that was very, very symbolic because it suggested that Delaware's dominance might not be that permanent as we all thought. By the way, let me just say, yes, of course I'm biased. All my career I spent studying Delaware law, teaching Delaware law, training others on Delaware law. I get phone calls from hedge fund managers, from venture capitalists, from institutional investors. What should we do? Our company's moving. I get those phone calls all the time. What's going on? What should we be advising our clients when they're advising large public shareholders, right? Companies that are publicly traded and have shareholders. What are their fiduciary duties? And so this signified something that perhaps other influential founders might migrate elsewhere, and that other states other than Delaware could potentially compete both politically or ideologically or based on all these things that, whether they believe it should be a race to the top or the bottom. And overall, for me as a corporate law scholar, could corporate law become more polarized? Are we going to see these major changes in corporate law? And why does it matter so much? Yeah, of course it matters to me because I write and teach, and consult in this area. And that is because historically, Delaware's dominance depended heavily on consensus, okay? Everybody, and by the way, it's not just locally, this was internationally as well. Everybody accepted the fact that Delaware judges are sophisticated. The Delaware law is predictable, which means it lowers transaction costs. That's extremely important for companies, especially publicly traded firms, but any firm, right? Because you know what to expect when you can predict what the case law. You can do business more efficiently. You know what to expect. And everybody also accepted Delaware governance as legitimate. And what Musk did, he challenged that consensus publicly, okay? And because of who he is, and that is one of the most influential founders, really, in the tech world and overall in the world, that change and that challenge mattered a lot, okay? And there was really even a bigger governance question here. And that is what happened. The battle that Musk had with the court exposed a deeper tension in our modern corporate law. And that is the traditional corporate model going to change? So let me explain. The traditional Delaware model is that the boards of directors and the courts really they constrain the managerial power through fiduciary doctrine. This is why we have fiduciary law, right? Because think about it as gap fillers. We can't expect everything, right? We cannot foresee everything, but we have these gap fillers that are supposed to reduce our transaction costs, and they make the game easily to predict. And we know what happens to whether what we're going to see in the future is a modern founder capitalism, okay? Whether visionary leaders or founders that are going to ask and demand for more control over companies, whether they're going to be able to gain that control without interference from courts. Are courts not going to interfere, or perhaps others will claim that courts are interfering too much in that leadership style and their ability to take risk and continue to operate their businesses. And what about innovation? I hear that argument over and over, that innovation requires freedom. Is there some sort of an effect here of telling the founders, you can't just do everything you want, you have to play by certain rules of the game? And what about the investors? The money, like I mentioned, institutional money, other types. What about investors or the public, retail investors? What if they buy into companies where they know that these companies are dominated by founders? And for example, we haven't even talked about the different types of classes. I'll speak about it as well because I did some research on this, and that is, what about the dual class stock versus others, right? And that is, there's really a battle between shareholder protection governance and founder-centric governance. What's going to prevail in the future? Are we going to be able to protect shareholders, or we're going to give founders more leeway and ability to do what they want? And so this really fits into what I'm describing in Delaware Beware, and that is that Musk didn't just win or lose a lawsuit or initiate a legal fight. It's much, much bigger than that. What we're seeing today is whether Delaware is going to continue to serve the needs of modern founder-driven companies. Okay, which, by the way, a lot of them are unicorns, the companies that I study, and these are privately held firms that are worth over $1 billion. Now, let me just quickly explain, why is it so detrimental to unicorns? Why do we care so much about this? And a little bit of myself, why I started studying this phenomena. So about 15 years ago, when I did my doctorate, I started studying these firms, that I observed something very weird happening in the market. So I practiced in the venture capital sphere. I used to represent either startup firms or venture capitalists that used to invest in them. And all of a sudden, I saw something I've never seen before, and that is that firms are staying private longer than 10 years, and they're raising large amounts of capital from non-traditional players. And what happened is that these firms were no longer just your regular startups, but they were more unique. That's why we call them unicorns. They were able to have at least reported valuations of over $1 billion. And I've never seen anything like that. And there were some other market trends that I was noticing, and that is that our public markets are actually shrinking. We have less publicly traded firms. The firms that we currently have stay public for less time than before, and companies or all these new technology firms choose to stay private longer. They're delaying their exits, and that has detrimental effects on our public markets. And so really we have to see these systemic changes in our market with what's going on here with regards to corporate law. There's many different things that are happening at the same time. And this is very existential for Delaware and overall for our corporate markets. And that is because states like Delaware depend on incorporations, on founder trust, on legitimacy, on network effects. And then what's going to happen if Delaware is going to be considered as a state that no longer understands this type of innovation? Now, let me say just one more thing, and that is, at the same time when I was writing Delaware Beware, because I could feel the changes were coming because I was sitting on those committees, I also decided to write another paper, and that is where do unicorns incorporate? Because I felt that not enough people understand these types of firms. And let's kind of quickly take a look at where do they incorporate? Why? Are they in Delaware? Are they somewhere else? Where do they choose to incorporate? And there were different theories until then. Okay, there were theories all the way through. There's a race to the top by Roberta Romano, race to the bottom, that's Bebchuk, Bargil and Barzuza. There were network effects, Klausner, and the most recent one is the lingua franca one with Jesse Freed. But nobody really wrote about the unicorns or took a look at the unicorns, because they always assume that there's like either a domestic or international competition. Domestically, we have Nevada, Wyoming, Texas, California. Internationally, we have Cayman Islands, British Virgin Islands, Bermuda. But what's happening with these firms? Because they're private, there wasn't that much information available about them. And so that is when I decided I'm going to take a look myself. I'm going to share some of that with you. I'm going to take a look myself empirically. And that took me a few years because it is very hard to find out that information. First, I had to gather the data set of the unicorn firms, and then I had to find out, again, they're all privately held firms. They're not public. You don't always have that information. I had to check where are they headquartered, and then where are they incorporated. And in Delaware, I had to do that manually with several research assistants. And you should know that after 10 searches, the Delaware system feels as if you're harvesting the system, and it makes it very hard for you to look. It slows you down. So it was me and multiple research assistants who were trying to figure out what's going on. Are these companies there? And it was, by the way, before ChatGPT. I didn't have ChatGPT back then, okay? That was before using AI today. And so I just wanted to see what was going on with these firms, because we don't have the traditional model. The traditional model is that you have a startup, they gain enough financing, then when it's not sufficient, they do an exit, there's an IPO, and they become a public company. But that completely changed. Because now you have startups, and if they're successful, they become this massive unicorn, and they remain private. They remain private even longer than 13 years. And I wrote a lot about this because it changes the way we do business. It changes the way our markets look. And what I found is that Delaware is the place that unicorns go to incorporate. 97% of unicorn firms in the United States, by the way, I also have an international study that I'm doing. I'm happy to share that a little bit if there's interest later on. Delaware is the place. 97% of the unicorns in the United States, that's huge. That's huge because let me just tell you, startups before, only 56% used to go to Delaware. So I wanted to check what happened. Why is it that I see that 97% of them incorporate in Delaware? By the way, let me just give you one more thing, and that is, this is also shows you the rise in unicorn firms, right? We didn't have that many before. It just kind of shows you when we started having unicorns. And let me give you a hint, I've written about that as well. That's thanks to our securities laws. So changes in our securities laws due to the Jobs Act actually opened up the ability of unicorns to raise so much money and stay private. Because of our security, before that change to our securities laws, they weren't able to do that. They had to register with the SEC. before, and Facebook changed that through lobbying. So Facebook had to go public because of our previous securities laws, and then they lobbied to change that. And thanks to that lobbying efforts and the changes to our securities laws, now you had that rise. So when you see that rise, that's because our securities laws changed. Now, 54% of unicorns are headquartered in California. You should know there was a very old study by Ed Rock where he showed that most of these firms used to actually incorporate in California. So something changed. So from that old study to my study, I wanted to check what changed, what caused this. And because I used to be, a corporate lawyer, I had a feeling it has to do with the lawyers, right? It's because it's the lawyer that recommends to the client based on their needs where they should incorporate. And I checked with the National Venture Capital Association. It's a trade organization, and they have form documents. And during my time, it was very different whether you practiced M&A in New York or California or Boston. The deal documents would look very different. And what the NVCA, the lawyers that sit at the NVCA, that's part of the network effect, what they try to do is make it more efficient, stream everything. And so they had form documents. And on those form documents, guess what is the default rule? Incorporate in Delaware. Okay, so if you're a startup and you use one of the law firms that is going to represent or does represent startups and deal with the M&A transactions or IPO in the future, they're going to recommend to you to incorporate in Delaware. Why Delaware? Again, because of efficiency, because we know what the case law says in Delaware, because we know that if we want something done or we need to approve something and we don't know how to structure the committee, what do? We call our friends in Delaware, right? A lot of the practice groups have offices in Delaware. And so you call your lawyer friend in Delaware and they tell you how to structure the deal so that you can cleanse the transaction. It's okay. I always say to my students too, it's okay to have a conflict of interest as long as you cleanse the deal. There's a process. If you follow the process, you can do that. And that's what lawyers in the courts want. They want the efficiency. The process matters. Process in Delaware matters. And so if you incorporate in Delaware how to do certain deals because that's industry practice, okay? And so what I found is that it was thanks to lawyers. And so now the default rule is to incorporate in Delaware. And by the way, still the NVCA, because I asked them, is that the default rule is still Delaware? They said, yes, it's still Delaware. And me and others are tracking, by the way, Steve Bainbridge has a great paper on this, and other people have papers as well. Steve's paper is called The De-Exit. He's checking to see who's exiting Delaware. I always check as well. And there's others depending on the states. One of my friends, Andrews in Nevada, has a study about Nevada, and others have about Texas if they're in Texas. And people are checking. But Delaware is still very much dominant today. And lawyers still recommend Delaware. And I will touch on that in a second of why, because it's still very predictable and we still have the same factors in place that cause what you're seeing here. And that is that even though 54% of the unicorns are in California, 97% of them still incorporate in Delaware. Although let me just put a caveat on that. And again, I've heard that Andreessen Horowitz, for example, recently recommended to their new startups to incorporate outside of Delaware. And so I want to follow that and see what happens there. Again, it's non-public information and it's based on reports that I saw. And so I have to check what is going on with that and what are the numbers that are associated with the new startups that are being backed by them. So this really shapes so many different things. For example, another thing that I'm sure you're seeing in Delaware and elsewhere, especially in AI, in artificial intelligence. And by the way, as we are speaking today, Musk is in another very famous litigation with OpenAI right? It's the gift that doesn't stop giving, right? He's giving us more and more gifts. And now he's got litigation with Sam Altman on the future of artificial intelligence. Which company is going to dominate that in the market? As you know, he merged two of his companies, SpaceX with AI, and he's suing OpenAI because he was an early founder there, and they're changing from a nonprofit status, public benefit corporation, to a for-profit model, thanks to Microsoft's investment and others. And that's really going to change. AI is going to change so much, because one more thing that AI is changing is I'm seeing all these acqui-hires in the market. And that is when, because of regulatory reasons like antitrust and others, companies can't just come, like Microsoft sometimes can't just come and acquire another company because of antitrust regulators might not approve it. So what they do is they either invest like they did in OpenAI. By the way, with that investment, they took an observer seat. They didn't even have directors on the board. They weren't able to for regulatory reasons. They just put an observer. Or they will do an acqui-hire. Well, they will just keep the company as a shell, but hire the top engineer and some of the talent, not all the talent. Sometimes they would leave the other talent in the shell that they're leaving for regulatory reasons and have a licensing agreement. And so everything I'm observing is changing even now when we're speaking, okay? So things are still, there's a huge evolution, and some are saying that employees are going to be detrimentally affected, because one of the things that drew employees to startups is that ability to gain equity and incentives. And again, because of all these changes, companies staying private longer, some are getting acqui-hired, others are staying in shells. The market as we know it is changing. And as you might know, one of the changes to Delaware law, because of the ball that started rolling because of Musk, Delaware changed some of his laws, are inspection rights. And that is also going to be very, very important. And that is, in some states, when you hold stock in a company, you immediately have inspection rights. In Delaware, there's always a caveat on that, because we also want to protect the company in case of competition and others. So there has to be a proper purpose for inspecting what's going on in the company if you want to open up the books. Now, so some people are using that to continue litigation, and with the changes to Delaware law, that changed as well. Some of the inspection laws have changed. I want to quickly pivot to, so what are some of the states that are competing, and can they compete, right? We talked about Delaware's dominance and the fact that Musk moved some of his companies to Texas. By the way, he also moved some companies to Nevada. And I'll talk a little bit about corporate law as a product. And it's not just about regulation, it's about business. Corporate law is a competitive product. States are competing. They offer governance packages. They include fiduciary standards, litigation environments, shareholder rights, director protections, founder protections, inspection rights, like what I just mentioned, takeover rules. And overall, you want to know what's the judicial philosophy when you decide to incorporate in a state. And so states have incentives, because incorporation generates massive amounts. That was one of my first slides of revenue. And so corporate law has also become an economic development strategy for states. And so that changes the way we should think about governance overall. Because once governance becomes a competitive product, the next question should be, what kind of governance is going to attract the most valuable firms to your state, okay? And historically, Delaware was able to answer that question extremely successfully. But what I'm trying to hint at today, that answer might be changing with regards to the other states, okay? So if I were an entrepreneur and I had to think about where should I incorporate, why would I choose Delaware versus other states, then we really would look at what are the benefits that I'm getting in Delaware, and that is still the case, and it's going to be very hard for others to compete. But I will have to say, a story, if you see, that happened before, because New Jersey used to dominate. And that is, in Delaware, you have the lawyers, the network of lawyers, you have the judges, the investors, and law schools, who are all the professors were deeply familiar with Delaware law. Okay? So switching away from Delaware law is going to become very, very costly. Now, so Delaware is already very valuable, and it's going to continue to be valuable simply because we all are already used to it. We're using it, and it's basically economics, right? It's like some sort of a lock-in. You're already in the system. Even thinking of myself, now I can't believe, if you would have asked me 2 years ago if I would be reading Texas or Nevada cases, I would tell you you're crazy. But now I'm starting to do that. I'm starting to take a look at what's coming out of Texas, what's coming out of Nevada, what are the new cases.
Anat,
Yeah.
if I could jump in briefly. So I think we're turning to who are the challengers to this Delaware monopoly, which is of great interest, obviously. I want to save time for a little bit of Q&A at the end. And so if you, I would invite you, who's your top three challengers? You've said Texas, Nevada. Is there a third state we should be looking at here?
Yes.
And what's unique? What is the comparative advantage or the new entrants offering to firms that makes them attractive potentially?
Sure. So I really think there's three states: Texas, Nevada, and Wyoming. And I will explain, it depends on the nature of the firm. Okay. And so this is really, I think, the most important development in our modern corporate law. And that is, Texas is competing for several reasons. One is ideologically, it's considered founder friendly, pro business. Also, some would say anti ESG, skeptical of activist litigation. It's going to be very hard to litigate there, and skeptical perhaps of some judicial intervention, but that is yet to be determined, because we have to take a look at the case law that's going to come out of there. And really, with Texas, it's about a cultural competition, a political competition, and there is already litigation and uncertainty, because again, we don't know what judges there are going to do, and you also have, because of the Constitution there, you have an ability to ask for a jury. And if you ask any litigator, having a jury on your corporate cases, that's not good. You don't know what's going to happen. There's no certainty there, and the costs are going to go up the roof. And so it's still there's still a lot of skepticism there, and not everybody's going to have the tolerance to move and do it. They're still waiting to see what's going to happen. Plus, the tenure of the judge is very short. And also, you always have to ask yourself, is it going to be a political nomination or not? Whatever judges sit there. Whereas in Delaware, I didn't say that, but it's usually very balanced, like the way they even elect judges and how they do that. And so it's going to depend on trust and what's going to happen there in terms of the network equilibrium. Are you going to find law firms moving out there? I've been hearing that, right? Services, like in Delaware still, you get a very quick turnaround. And that's what's actually going to get me to talk about Nevada. Nevada offers a very, very different model. Very different model. Here, let me see if I can even share this slide with you quickly. Why did I put fraud on there? Because my colleague Ann Lipton always used to joke. She used to joke and say, you're going to Nevada because, you're going to do not so kosher things when you go there. Okay, so Nevada competes by offering a stronger liability protection, less plaintiff-friendly environment, and in some respect, it really tries to market itself as a jurisdictional state for managerial protectionism and reduce litigation, right? But there's critics to that, and that is you're going to have weaker, perhaps, accountability. And that's going to become very, very important, especially when you're talking about a large publicly traded firm, because you want to protect retail investors, right? You always have those challenges there. And are investors going to be willing, because smart money going to be able to willingly take companies to Nevada where they know they might not have as many protections before the court? And so that's why there's a lot of tensions that are going to shape the way that our modern corporate governance is going to look like. I want to say one more, just a final word on Wyoming. Some people are surprised to see Wyoming on there, but that is because this is really the most fascinating competitor, at least it was to me. And I think what Wyoming is doing, they're not just trying to replicate Delaware, but they're doing something very different than the other competitors. They are really trying to create a governance infrastructure for digital assets, for decentralized organizations. And so this is really when you're going to see a lot of the blockchain governments, the DAO legislation coming out of, and they raise all these types of different questions. And that is, could the future of corporate governance become machine readable? And could governance increasingly operate through smart contracts? And could code replace traditional fiduciary enforcement? And I have several papers on this with Nitzan Packing as well, where we discuss these changes to the law. Because remember, the Delaware's power historically really depended heavily on judicial intervention. And here, what you have is these developments challenge our foundational assumptions of corporate law, and they're also mixing in securities, even though securities are supposed to be governed by federal, right? You also have state securities laws, and they're trying to give you some sort of safe havens according to their state securities laws, but what happens on the federal level. And so a lot is going to happen there as well. So yeah.
Hey, Anat, can I ask you a quick question about on the empirical side?
Sure.
So what are you seeing empirically in the moves currently, and both on the unicorn corporations, but also, these unicorn companies, but also on the other players, right? So is there a split? What do you see sort of demographically in the companies that are moving or staying in and out of Delaware?
So let me just start with this. This is a great question that we have seen some movement, not as much as people would expect, okay,
Yeah.
because of all this public outcry. So Delaware is still very much dominant. And I would expect that because if you think about it, right, whenever you have a publicly traded firm, they're very conservative. They have to take retail investors into account. You have to disclose to the public if you're going to reincorporate, and they have to justify the reincorporation. You also have to get a vote. And you have to be very concerned about the fiduciary duties when you're relocating, right? Which state are you going to relocate to? For example, Nevada. What would I expect? First of all, overall, Bainbridge raised it right away, and I agreed with him, and that is that if we would expect any type of exit is the type of firms that are controlled by founders, like dual class and others, where you might not be able to tell the founder what to do because of that structure. Investors invested in those companies, they're controlled. It's going to be very hard for activists to do anything there. That's why sometimes I laugh when they're saying, oh, this activist bought stock in whatever, this company that I know is dual class. I'm like, and what are they going to do? They can buy all the non-voting stock, but they can't vote. So which means they can't tell you what to do. And those are the types of firms that I would expect to move and also I think there's a price associated with that. The next thing I would like to see is calculation of the Delaware premium. There were studies in finance before that showed that if you were incorporated in Delaware, your stock would be traded higher. And so I would like to see the ones that have moved, whether the stock price went down accordingly, whether the market priced them accordingly. And so the ones who are more in trouble or problematic or about to go through bankruptcy or, not as insolvent or the financial don't look great, I'll probably expect them to go to places like Nevada. The interesting move is the one to Texas, because there what they did in Texas, it's actually much harder to litigate. You need to own about 3%. So who could possibly litigate? The large institutional investors, like the big players. I don't really see BlackRock, Vanguard, State Street starting to litigate against companies, right? So who's going to be able to bring litigation in those states? It's going to be very, very hard. And so it will be interesting to see what happens in Texas, especially since, again, we still don't know what's going to happen with the business courts that they're establishing, what kind of cases are going to come out of it. And let me just say one more thing. Business courts are not new. We've had them before. We have it in New York. We have it in other places. And so it's not like all of a sudden Texas just came out with this new structure. And I stated that in my paper, and I'm happy to say it again. I still think they have a lot of work to do. And that is, they need to do certain things if they really want to compete, to their laws, to the way they choose judges. So I still think that we're going to see some movement and changes there.
Anat, we just had a very interesting comment from the audience in the chat, which is right on point with what you're discussing. I'm sure you've heard this. Dell, the computer company, just voted to move from Delaware to Texas, and now Dell, they have Michael Dell is the founder, so it's kind of founder-led. That's a big public company, and so I'm wondering, your paper might even be more prescient than you think in terms of not just unicorns, private companies, but also maybe some big public companies making the leap. If Texas or these other states gain some market share, do you see any response from Delaware? Would it come from the courts? Would it come from the state legislature kind of overruling the courts? Does Delaware have any opportunities to claw back some of this business to the extent this gets momentum?
So this is a great question. It's already happening. And so we spoke a little bit about the fact that there were some changes to Delaware law and also what the Supreme Court did in Delaware. So let me just say a few things. First of all, even the cases that were in question, they were about process. And so even about Musk, if he would have followed the process, we wouldn't have even been here. There wouldn't even be litigation. That's one. Second, what the Supreme Court signaled afterwards, and that's the way it should have been, before the Supreme Court interfered, there was so much pressure put on the legislator that the legislator actually went and made some changes to Delaware law. This hasn't been done for a while. It has been done before, but not for a while historically, by the way. That's how we had some other amendments to Delaware law. And now we have these amendments. So they didn't even wait for the Delaware Supreme Court to interfere. Lobbyists pressured the Delaware legislator. I even spoke before Senate and others on the proposed legislation and the changes. And I urged them, I said, just wait, let the Supreme Court make a decision and make things, at least more comfortable for some of the lawyers, answer some of their concerns. You might be surprised with the rulings. And what I said actually happened. And that is the Supreme Court, when they did hear those cases and when they did rule, by the way, they didn't say the Chancery was wrong on the process. No, they know that process is process, and process in Delaware is still predictable, but they came to a middle way. Okay, and that's what is so unique about the Delaware Supreme Court, is they were able to do that, right, and alleviate some of that tension. By the way, some of the changes that were done in terms of the laws in Delaware already went into effect, and some lawyers, corporate lawyers that I spoke with, because I sit with them in the committees, are very happy about the changes. Okay, I personally thought the changes were not necessary because I knew the Supreme Court would, make a decision that the way they did, but they liked the changes. And by the way, changes were made before historically, like 102b7, other provisions that were added, changed in Delaware Code that's happening today as well. And these are responses from both the legislator and the court to answer this mounting pressure. Now, does it mean that other large companies are not going to move? We're going to see. But like I said, I think they're going to be founder control, because those are companies that it's very hard for you as an activist to go and influence. So those are the ones that I believe we might see moving, and even not all of them, but some very large names. And yes, let's see how they play in Texas, and let's see what they do, and how litigation there is going to look like. But things have changed for sure. And I didn't even mention it yet. To me, the real challenges are really coming from, we didn't even talk about a federal and also international competition. Okay? When I say federal, it's really our securities laws and how much they're going to creep into. And there are some voices, for example, Elizabeth Warren and others, who believe that we should federalize corporate law. I personally don't think so. And many in corporate law kind of agree with me. And this is not the first time we've heard those voices, but there are voices that think that it shouldn't change from state to state, or that one state shouldn't be as dominant, but it should be the federal government that dictates and federal law. Again, I personally don't see that much happening there. I could be wrong. But we're seeing it with regards to the latest SEC decision with regards to even proxy and what we call the proxy practice, and the ability to raise proposals as shareholders and no action letters, right? That practice recently changed. And even that has a huge, I have a new paper on that as well. It's coming out soon. It's not public, it's not on SSRM, but stay tuned. I've written about this. And the effects that that has on one of the things I told you today, and that is shareholder power. Can shareholders continue to propose suggestions to management and directors in annual meetings? That's one. And the other is really with regards to outside influences. The largest competition that I saw was actually coming from places like Cayman Islands, right? And other jurisdictions where there you have tax and foreign companies, for example, a lot of the Chinese companies, right? A long, long time ago, some of them used to also incorporate in Delaware because they wanted to access our public markets. And now some of them are going to foreign jurisdictions. Many of them are actually going to, so you have all these foreign unicorns. They're going to foreign jurisdictions, but some of them are listed here in the United States. The founders are not here. The incorporation is not here. Who's going to hold them accountable, right? Let's see something happen and there's fraud, there's issues going on. How are you going to even hold these companies accountable? And
we have not,
yeah.
If you don't mind me interrupting, we have one last pretty good question from the chat, and then we have to wrap it up. So what final closing question? The audience member wants to, why in the world is this in the best interest of shareholders to reincorporate to leave Delaware? It occurred to me that there's different types of shareholders, and one divide here seems to be like private equity versus the institutional investors like the State Street BlackRock people. Because I know Silver Lake Partners has a big position in Dell. And does it really matter who your shareholders are in terms of the taste for reincorporating, in addition to maybe having a founder?
Absolutely. And by the way, I think it's important to all the institutional players, and I'll tell you why, but especially large institutional players, because there's ERISA rules, there are fiduciary duties on the institutional investors and other investors as well. So let me separate the two. Venture capital, acts very differently. You have the management team, and they're the ones who make the decision. You have the passive investors that invest in them, right? But they have to take that into account as well, because the passive money, right, the institutional money that goes to the LP, to the limited partnership, they have fiduciary duties to their beneficiaries. They have to make sure that they're supervising the money that's going in. And so if you know you're relocating to a jurisdiction where you might not be able to have a say as an investor, that's a big deal, okay? So where you are incorporating and what shareholders can say or not matters a lot, because the fund investors as well, the ones who are managing, they have fiduciary duties. Those are remember I told you I've been getting phone calls? Those are the phone calls that I'm getting, because lawyers immediately know that. Wait a minute, our clients have fiduciary duty, right? Even if they're passive, even if they are passive investors, because they need to know which vehicles they're putting their money in. And so it matters greatly.
Great. I think that's a perfect place to end. So thank you, Anat. We appreciate your talk and your comments. And thank you all, everyone else, for tuning in. Today is our last speaker of our spring session, but we will be back with another round next fall, starting in September. So till then, thank you, and we'll see you soon.